for today's topic, I've chosen common intention, similar intention, and common object as my topic. So, in criminal law, what is the difference between these terms? Are these terms of any difference, or what? Why we should actually deep dive, than just what these words in criminal law? As I'm sure you all know, that the initial onus, at least, is always on the prosecution to prove a case against the accused person. But let's say you are representing an accused person and charges have been alleged, or some allegations have been alleged against your client. Whether those allegations are correct, whether the sections which they have applied are those correct or not, you'll have to see that, we'll have to argue in court that the section which the prosecution intends to try your client with is not clearly not applicable to you. So there is the importance to understand the difference between these terms. Now, common intention, as you all know, is not a offense as such, because if you see under the IPC, it comes under Schedule 2, which is only definition. So common intention as such is a constructive liability under criminal law, through which an accused person, even though he may not have done any overt or covert act, can be tried and finally convicted and punished. So common intention is defined under Section 34 of the Indian Penal Code 1860. I'll just read it for the benefit of all. 34, which says, act done by several persons in furtherance of common intention. When a criminal act is done by several persons in furtherance of common intention of all, each of such persons is liable for that act in the same manner as it were done by him alone. So if, let's say, two people have a common intention and one of them commit a crime, the other one, even though he did not commit a crime, only he had the intention with the first accused, but because he shared that intention with him and there was a common intention between them, he will also be liable. The second accused will also be liable as if he has himself committed the crime. So this is basically the definition of common intention. Now, common object as such deals with crimes in which there is an unlawful assembly. 149 of the IPC deals with common object. I'll just read it. Every member of unlawful assembly guilty of offense committed in prosecution of common object. If an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing of that offense is a member of that assembly is guilty of that offense. So in criminal or in common object also, even if you are a member of an unlawful assembly and if you don't personally commit a crime, but if the assembly commits a crime in furtherance of the common object of whatever that assembly was formed for, you will also be liable for it and be punished under 149 with the help of 149. Similar intention as such is not defined under the IPC, and similar intention just means that the intention is there with two people who may not share it. It may not be common there, but they individually think of something common, which may be common. The object may be common, but the intention is not shared with. So that's what similar intention comes in. I'll just give you a few examples so that the difference as such, comes to you. Now, let's say there's this guy Ajit who is going to meet Malti and her parents. Now, Ajit, who is a prospective groom, I don't want him to meet Malti and her parents. I, with my friends, decide I'll stop Ajit on his way to meet Malti's parents and Malti. And there's another group of which is also an unlawful assembly, because my object is also to restrain someone, is to commit a crime. So in that sense, I am also a part of an unlawful assembly. There's one more assembly where whose intention is to kill Ajit, because they are the business rival of Ajit. Let's say I stop Ajit and to try to restrain him from meeting Malti, but someone from the group B whose intention is to kill him comes and shoots him. And can I be tried with the other group? Can the police say these all people had a common intention of killing Ajit and that's why they should be tried together and they should be convicted? So in such a scenario, when two different groups who have different common objectives are tried together, you can always argue in a court of law that, look here, the object of the first group was very limited. It was to restrain him so that he doesn't go and meet her, while the object of the second group was to kill him, and that object has been fulfilled. But that object had nothing to do with the object of first group. So that's why the people who are parties, or the people who are the members of the unlawful assembly of group A, cannot be tried for murder which has been committed by the group B. So this is basically the difference between common objects of two different groups. I cannot be tried for something I have not done because that was never my objective or my intention. I'll give you one more example. Let's say a builder has a building and there's a tenant in that who's not vacating the premise. Now he says to his politician friend, I'm trying to redevelop this building, but this tenant won't leave the premise. Now that political or someone from the local area hears that and says, you know what, if I vacate this property and give it to that builder may pay me handsomely. And because of this, there are two groups in the locality. These two groups individually take the onus upon themselves and say, I'll vacate this and give this to the builder with an intention to get money from me or whatever it is. Now, let's say there are two groups here also. If one group has the intention to just scare that tenant and get the property, but another group has the intention to beat him, to break his bone or whatever, some aggravated assault, can these two groups eventually, if they are tried, can they be tried together? They cannot be tried together because the common object of individual group is different. The object of one group is only limited to scaring the tenant so that he vacates it, whereas the other group's intention or common object is that we should break his leg so that he leaves out of being scared. So the object of two groups are different. So these members of these two groups cannot be tried together. They'll have to be tried, one under with the intent only to intimidate him, and one with the intent to assault him. Now, what is common object? Now, this goes to different. There are multiple groups, and there are different objects of different groups. Of course, this can happen. But what happens only if there's one group? Of course, if there are two groups, then one group is only liable for the object which that group had and not for the object of another group. But what happens if there's only one group, and in that one group also someone has a different intention which is different from the object of the group? Then in that case, obviously, let's say there are five people. The object of the group is to restrain someone. In the first example itself, if the object is only to restrain Ajit, but if one of my members of the unlawful assembly of my group says, you know what, I have some personal grudge against him, I'll shoot him. He doesn't tell us this. We go to restrain him and he removes the gun and shoots. Can we all be tried for murder for 302? No, because our object of the group or the unlawful assembly was very limited. It was only to restrain him. So if one of the members goes ahead, removes a gun and shoots him because of his personal rivalry with him, we all cannot be tried for it because the object of the group and the object of that individual was very different. It was not overlinking, so we cannot be tried for the offense of murder. Now, what is common intention? Usually in common intention, the intention between the parties is shared. Now, that intention is usually before a crime is committed, it is there. People sit together and say, this is what we are going to do. We are going to do this. This is our plan of action. In that case, there is a common intention because all the accused persons agree, yes, this is the course of action we should take. Then there's a common intention between them. But of course, common intention can also form on the spot. If, let's say, in the first example, if we go to stop or restrain Ajit, and in that sense, and there's some altercation between me and Ajit, and I say, let's kill him, and all the members of the assembly agree, then even though our object was very limited, since we have I've said that let's kill him, and all the other members of the unlawful assembly has agreed to it, there is a common intention between all of us to kill him. And so if he is killed, then all of us are liable for 302 read with section 34 of the IP. So that is common intention. When the intention is there, which is usually comes before the crime, but it can also happen on the spot. Now, if, let's say, of course, you have understood the basic difference between common intention and common object, that intention may be shared before a crime is committed. An object is not same as an intention. Well, a common intention is, I've already told you, not an offense in itself. It's only a definition under section 34 of IPC, under chapter 2. It is only to constructively other accused person also should be tried. So what are the prerequisites of common intention and common object? Common intention, at least two people are required, and there need to be a crime crime or an offense committed in furtherance of their common intention. So in common intention, only at least two people are required, whereas in common object, at least five people are required, and there need to be a crime or an offense committed in furtherance of that common object. That is the requirements of common intention and common object. Now, of course, for prosecution to discharge this burden, that the accused person had a common intention or a common object, it will not be easily or readily available, and the prosecution may have to show from the fact, the weapons the accused persons were carrying to prove the common intention or the common object of the unlawful assembly. Now I'll just take you through the case laws. In similar intention, basically, there's not defined under IPC as such, but I'll just touch upon it here. Similar intention just means that if two people individually have similar or same intention, let's say someone is sitting on a street and their wallet is kept next to them. Two people at the same time have the same intention of stealing that wallet. So they may have not shared that intention with each other. So there's no common intention as such, but they individually had the same idea or they had the same intention that let's steal his wallet. So in that case, they cannot be tried together with the help of Section 34 because there's no common intention between them, but they can individually be tried for the offense. So in that case, if the prosecution tries to say that these two persons should be tried together, then it can be argued that since these two people had similar intention or same intent, they both had the same idea, but since they didn't share this intention with each other, there's no common intention and they cannot be tried together. I'll just take you through case laws so that you can understand the topic in much detail. The first case law is Krishnamurthy versus State of Karnataka, 2022, 7 SCC 521. In this, what has happened was there were several accused persons, and they went and they were assaulting the deceased or the victim, and one of them, he jumped on him, he pinned the deceased down, he broke his rib, and he traumed him. There was contusion, there was spinal cord injury. So the question before the court was whether the other accused person could also be convicted for murder because this accused person has only done the most damage. So the Supreme Court, while dealing with the concept of common intention, said the underlying basic assumption or foundation in criminal law is principle of personal culpability. Of course, there's no liability as a vicarious liability as such under criminal law. If you commit a crime, you're personally liable for it. A person is criminally responsible for acts or transactions in which he is personally engaged or in some other way had participated. Of course, if you participate or you commit some crime, you are liable. However, there are various modes and capacities in which a person can participate in a crime. He can instigate, be a facilitator, or otherwise aid execution of a crime. So, of course, not just that you have personally given a blow to the accused person, you can be liable. There are other ways you can be liable. You could instigate other people. Yes, let's kill him, or you kill him, or you can hand him over a weapon. So all these actions can also be considered while granting punishment. And the court can say, yeah, this person has also not personally, dealt blows to the deceased person, but this person has instigated others. This person has given weapon to other accused person. Section 34 incorporates the principle of shared intent, that is, common design between the two perpetrators. Like I said, in common intention, when it's the shared intention or the common intention between all the accused persons, which makes the second or the other participant also an equal or joint perpetrator as the main perpetrator. Section 33 of IPC, a criminal act in Section 34 IPC includes omission to act. So 33 also says even if you omit to do an act, then also with 34 you can be charged. Does a co-perpetrator who has done nothing but has stood outside the door while the offense was committed may be liable for the offense, since in crimes as in other things, they also serve who only stand and wait. So what happens if a person individually doesn't take part in the crime, but he only stands? Can he be committed to criminal trial and can he be convicted? The answer is yes. If some five people decide, let's go and rob someone, and one of them says, I'll stay at the door and see if some watchman comes, I'll alert you guys if someone comes. Even if he personally did not commit the act of robbery or dacoity in this case, because there are five people, he still will be liable because he stood outside, he stood guard, to see if someone is coming to alert the other accused person. So of course he will also be liable in law. Normally, however, in a case of an offense involving physical violence, physical presence at the place of actual commission is considered to be safe for conviction, but it may not be mandatory when pre-arranged plan is proved and established beyond doubt. So usually, when there's a physical altercation and when the accused persons go and physically assault them, it is better. The courts are usually more happy to convict someone if the accused was physically present there, because there may be an intention way before the offense is committed, and afterwards, that offender may not be there. So usually, as a general rule, it's better that if the accused person is present. But even if he's not present, if the prosecution is able to show that there was a common intention, that before the crime was committed, these accused persons formed a common intention, and in pursuance of this, they have executed this or they have done this offense, that person can be tried and punished with the help of common intent. Inferences as to common intention should not be readily drawn. Culpable liability can arise only if such inference can be drawn with a degree of assurance. If the criminal offense is distinctively remote and unconnected with the common intention, Section 34 would not be applicable. So the court says that if the intention of one of the accused persons is very different from what was decided earlier, it has nothing to do with it, then of course that other accused persons cannot be tried together, and then that individual will be himself guilty. The next case is State of MP versus Deshraj and others. In this, what has happened was there was some vulgar altercation between two villagers due to some fare that was decided between them. One was saying it should be X amount, the other was saying it was supposed to be X plus one amount. So there was physical altercation, the first vulgar altercation, then physical altercation. Then it ended up killing the deceased person. And the prosecution said all the accused persons who were present should be tried for 302 read with 34. So what the court said is Section 34 has been enacted on the principle of joint liability in doing of a criminal act. The section is only a rule of evidence and does not create a substantive offense. Of course, it's not a substantive offense. It's only a liability through which it's created, a constructive liability. It's not a different offense. Unlike 149, for which a different charge will have to be same. You can't just at the end stage say that there was a common object. But unlike 149, 34 can be invoked at the later stage also if the prosecution is able to show that even though there was no common object, there was a common intention. And then the accused person cannot say that the charges under Section 34 of ICC were not framed, because these are not substantive charges. The distinction of this section is the element of participation in action. The liability of one person for an offense committed by another in the course of criminal act perpetrated by several persons arises under 34 if such criminal act is done in furtherance of a common intention of the persons who join in the committing the crime. Direct proof of common intention is seldom available, and therefore such intention can be inferred from the circumstances appearing from the proved facts of the case and proved circumstances. Of course, common intention cannot be very readily available. You will have to look at the facts which have already been proved to see if there was a common intention between these parties. In order to bring home the charges of common intention, the prosecution has to establish by evidence, whether direct or circumstantial, that there was a plan or meeting of mind of all the accused persons to commit the offense for which they are charged with the aid of Section 34, be it pre-arranged or on the spur of the moment, but it must necessarily be before the commission of crime. But in this case, as there was a sudden quarrel and there was no premeditation in that sense, because there was just a verbal altercation which ended up getting someone killed, the court said that in this case, since there was sudden quarrel, we cannot convict them under 302, we'll convict them under 304 Part 2. The next case is Arun versus State, 2008-15 SCC 501. In this case, there were two accused persons. What had happened is they entered the entrance of the deceased and they stood there. The deceased saw them. He came and said, "What happened? Why are you?" One of them removed his gun and shot him. And after he was shot, they both left the scene of crime. The question before the court was whether both of them had a common intention or a common object to kill the accused person. The prosecution obviously led the case, showed brought the witnesses forward, husband, wife, mother, they were all brought. This initial, when the FIR was lodged, they said that one of the accused shot and both of them left. They did not say whether the other accused also had a gun, whether he had said something which instigated the first accused to kill him. So the role of the second accused was very limited. And even in the stage of examination and cross-examination, the mother of the deceased said that the one of the accused person was carrying the gun, and I don't remember whether the other accused was carrying the gun or not. So taking all this in consideration, the court said, from what we can see, from starting to end, the second accused did not share the intention with the first accused, so we cannot convict him with with the help of Section 34. So what dealing with this, the court said was the appellant did not indulge in any overt or covert act except be present at the scene of occurrence. And while dealing with whether this intention or the plan before the commission of murder should be very detailed or it could be very brief, the court said the plan need not be elaborate, nor is it long interval of trial required. It could arise and be formed suddenly, as for example, when one calls bystanders to help him kill a given individual, and they, either by their words or their actions, indicate their assent to him and join him in the assault. So it need not be that the premeditation should be very well thought of, or it should be that there should be some certain time gap between premeditation and the commission of crime. So it can be short also. There can be as long as it's there before the commission of offense. The accused persons can be tried together with the help of Section 34 of the IPC. The necessity is meeting of mind. There is a pre-arranged plan, however hastily formed and rudely conceived. No evidence whatsoever available in this case, so he was acquitted finally. So the next is Chanda and others versus State of UP and another. 2004 5 SCC 141. In this, there was an old enmity between the deceased and the accused person. So when the deceased person was returning to his village from city, the accused person, along with his brothers and some of his friends and family members, was standing at the entrance of the village with a revolver. And as soon as the deceased came, he pointed out the deceased revolver at him and said, he should make sure that he should not escape, and fired a bullet at him. But he missed him. Then all the other accused persons chased him, stopped him, and one of them shot him. So the question was before court, can all of them be tried together and can all of them be convicted? So court said, but in this there was only a common object because there was no premeditation on the account of the accused person. They were only standing, and when he came, one of them said, then let's kill him, and all of them jumped in and said, yes, let's kill him. So there was only a common object, not a common intention between them. The object was to kill them. So the question was whether they all can be convicted with the help of 149 of IPC. So while dealing with the applicability of 149, court said the provision has its foundation of constructive liability, which is a sine qua non for its operation. The emphasis is on the common object and not the common intention. Mere presence in an unlawful assembly cannot render a person liable unless there was a common object, and then common object is one of those set out in section 141. Where common object is not proved, the accused person cannot be convicted with the help of section 149. So of course, as always, the initial burden is on the prosecution to prove that there was a common object of all the accused persons of the unlawful assembly to kill a person or whatever, to commit a crime as prescribed under 141. Once that is done, then the accused person can be tried and convicted with the help of 148. The word object means the purpose or design, and in order to make it common, it must be shared by all. It may be formed at any stage by all or a few members of the assembly, and the others may just join in and out. So it's not unlike common object when all the accused persons say, yes, we agree to this. In common object, I may have an object with someone and others may just join in. They may not have that object initially, or that object, whatever is that may be amended, modified, changed, doesn't matter. So object in that sense is different than intention. It may be formed at any stage by a few members, and others may just join in and adopt it. Once formed, it need not continue to be the same. It may be modified, altered, abandoned at any stage. The expression in prosecution of common object as appearing in section 149 has to be strictly construed as equivalent to in order to attain the common object. It must be immediately connected with the common object. Common object is different from common intention as it does not require a prior consent and a common meeting of minds before the attack. So in common object, there's no need for there to be a prior meeting of minds. The common object of an assembly is to be ascertained. Now, how is whether an assembly may be lawful, but it may also turn later on unlawful. So how do we ascertain whether an assembly is lawful, unlawful? The common object of an assembly is to be ascertained from the acts and language of the members composing it and from a consideration of all the surrounding circumstances. It is not necessary under law that in all cases of unlawful assembly with an unlawful common object, the same must be translated in action or be successful. So it need not be successful also, but as long as it's there, yes. So that is basically the difference between them, object and intention. Intention, there's premeditation. The next case law is Bhargava and others versus State of Kerala, 2004, 12 SPC 414. In this, the deceased went to the market. He was brutally assaulted by few accused persons with iron rod, motorcycle chain, sticks on his head, neck, and back. The question before the court was whether the assembly consisted of five or more persons and whether the said persons entertained common objects as specified in section 141. The court said that it cannot be laid down as a general proposition that unless an overt act is proved against a person who is alleged to be a member of an unlawful assembly, it cannot be said that he is member of the assembly. So when there's a common object, need not be that every accused person has some act, some of them may act, some may just stand there, be guard, or just instigate others. As long as they are there, they know that the assembly is unlawful and that the object is unlawful and they remain there, they can be convicted. The only thing required is that he should have understood that the assembly was unlawful and was likely to commit any of the act which falls within the purview of section 141. The time of forming of an unlawful intent is not material. An assembly which is at its commencement or even for some time thereafter lawful may subsequently become unlawful. In other words, it can develop during the course of incidents at the spot eo isciente. So it does not mean that an unlawful assembly should be from the inception. There may be an assembly which is lawful, but later on then the object changes and they turn into an unlawful assembly. So it can also be on the spot. But does this mean that everybody who is standing or a mere bystander or who's just standing there can be convicted with the help of 148? Of course not. A mere bystander will perhaps not intervene because of fear that something might happen to him also if he tries to stop the accused person. So he may just stand there, witness all of it, but not do anything. But can it just because of that we said that he's also liable under 114? Of course not. Because in India, as you know, if a crime is committed, if a lot of accused persons are there, if weapons are involved, people may not get involved because no one wants to take the wrath of the unlawful assembly upon themselves. But they may just stand there and watch, so they cannot obviously be tried for the offense. So mere onlooker or a bystander cannot be tried. But of course, even if you're a member of that assembly, even if you don't participate, if you're, let's say, only driving a car in which the other accused persons are carrying the weapons and then subsequently they, in furtherance of the common object, beat someone up, then even if you are only driving, but you knew that this assembly was unlawful, yet you remained with them, so you will also be tried and convicted for it. The next case law is Masalti versus State of UP. In this, the question before court was, and there are a lot of accused persons. Let's say there are 200, 300 people. A crime is committed by a lot of people. We don't know who exactly did it. Then what happens? The court said, of course, in cases like this, when there are 200-300 accused people, you cannot expect the witness to observe overt act of every accused person. Some accused persons, the witness will be able to tell, yes, this person was involved. Yes, this person was involved, or this person did this, he used this weapon. But when there are two, 300 accused persons, of course, it will not be possible for the witness to give specific role to all the individual accused persons. So in that case, with the help of Section 149, the prosecution says that, look here, there are these two, 300 people. These two, 300 people formed an unlawful assembly and they committed this crime in furtherance of the common object of this unlawful assembly. These accused persons have been specifically named by the witnesses. These other members were also members of this unlawful assembly. Now, with the help of 149, these other accused should also be tried and convicted. So that's how 149 works. So in this case, what Supreme Court said is AIR 1965 SC 202. Crowd of assailants who are members of an unlawful assembly. It is often not possible for a witness to describe accurately the part played by each one of the assailants. It is not necessary that all of them have to take part in the actual assault. The appreciation of evidence in such a complex case is no doubt a difficult task, but criminal courts have to do their best in dealing with such cases, and it is their duty to sift the evidence carefully and decide which part of it is true and which is not. So, of course, the court will look at the evidence of all the witnesses present and then decide what punishment needs to be given. But there are a lot of people, of course, you cannot expect that a specific role will be given. But that cannot help the accused persons to say that there were 300 people. How do you arrest me? Because you are also a part of that unlawful assembly. Now, the next case law is Abdul Saeed versus State of MP, 2010 10 SCC 259. In this, the accused persons were initially charged with the help of 149 of the IPC, that is a common object. But later on, the accused was eventually convicted with the help of Section 34 of the IPC. So other accused person said, how can this be done? I was not tried for the offense under 34 of the IPC. The court said that 34 of the IPC is not a substantive offense, so the formal charge need not be framed. And if the prosecution is able to demonstrate that you have committed a crime and that you had an intention, common intention with the other accused person, you can be tried and convicted. There is no bar in law on conviction of the accused with the aid of Section 34 IPC in place of Section 149 IPC if there is evidence on record to show that such accused shared a common intention to commit the crime. Section 34 of the IPC does not create a distinct offense, but it lays down the principle of constructive liability. High Court rightly proceeded in convicting them with the aid of Section 34 IPC, setting aside the conviction under 147, 148. Now, let's say there are 6 people, and out of these 6 people, some may have some other intention which is different from the common object of the unlawful assembly. Can the others be tried for the individual act? Of course not, like we have already discussed. Then what happened? So in this case, there were 6 accused persons. Now, 2 of the accused persons had the intention to kill the person, while other 4 had the object of only to assault him. So the court, after going through everything, said, look here, these 2 people had the intention to kill him. So these 2 will have to be tried independently for murder 302 because they had the intention. While the other accused person, they had the object of only to assault him. So we cannot convict them for murder, but of course we can always for causing harm we can convict them, and they were finally convicted under 324 read with 149 of the IPC. The court, basically. In the next case law is State of UP versus Subhash 2022 6 SCC 508. In this, initially there were 7 accused persons, out of which 3 accused persons were charge sheeted, and out of which only 1 or 2 were finally convicted. So the accused person said, how can you convict me for 148 of the IPC, which is causing riot with a dangerous weapon, if the initial thing of 5 persons is not there? Because only I am being convicted with the help of this, but others have been acquitted. So the court said, because why this contention of the accused person was taken is, if you see unlawful assembly under IPC, which is 141, an assembly of 5 or more persons designed with an unlawful assembly, common object composing of assembly is to overawe by criminal force, show criminal force to central or state government or parliament or legislature or state or public servant in exercise of lawful power of such public servant, or to resist execution of any law, or to commit any mischief, criminal trespass, or other offense. So if you see the first line itself, it says assembly of five or more persons. So the accused said, here to only I am being convicted with the help of 148, which you are saying is rioting. And if you say rioting with deadly weapons, which is 148, whoever is guilty of rioting, being armed with deadly weapon or with anything which was used as a weapon of offense, is likely to cause death, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. So here he's saying there was no unlawful assembly. I am the only person who's been convicted. So how is the question of 148 been applicable? The court said that the contention of the accused that 148 is not attracted as there are less than five persons cannot be accepted. And why this cannot be accepted is, in the beginning, when the complaint was filed by the deceased, who gave a dying declaration saying that 6 to 7 persons have assaulted me, and he subsequently succumbed to his injuries. The court said that when the accused person gave that dying declaration, then that unlawful assembly in that sense is proved by the prosecution right from the very beginning, and even so stated in the dying declaration. 6 to 7 persons attacked the disease. Therefore, involvement of 6 to 7 persons in commission of the offense has been established and proved. Merely because three were only charge sheeted, charged, or tried, and even out of three tried, two came to be acquitted, cannot be ground to not to convict the present accused under 148 of the IPC. So even if there are eventually, if there are not five people who are convicted, initially if there are five people who have committed the crime, they can be tried with the help of 148, and they can be convicted, is what the court said. So of course I'll just now give an example of similar intention, because similar intention is just to give you a clarity that there's a difference between common intention, common object, and similar intention. What is similar intention? Let's say there's a P is a political leader, and Q is also his political rival. Now P wants Q to be dead, and he places a reward on Q's head and says, whoever kills him, I'll pay him X amount of. Now there are two people who are hitmen, who are in the business of killing people for money. Now these two people individually say, I'll kill him for the money on his head, and they go to kill him, and one of them is successful in killing him, and the other person is caught even though he didn't commit the crime. He is caught, and both the accused persons are caught. Can both of them be tried with the help of, can the prosecution say that they had a common intention to kill him? Then if you are for the accused person whose intention though was to kill him but was unsuccessful in killing him, you can always say that, look here, although I had the same intention, although I had the same idea that I should kill him and get the money, or I had the similar intention with him, I did not share this intention with the other accused person who was successful in killing the person. So there is no common intention between us, although we have a similar intention. So I cannot be tried with him with the help of section 34, and he'll get the benefit of doubt by the court. So this is what similar intention or same intention in short. So I think so that was about it. We can just take questions if you guys have any questions.
Ashish, if X and Y, okay, at a party drunk, they jokingly
Yeah.
discuss that we should kill Z. They both have
Mm.
enmity with Z, and
Okay.
X goes ahead and kills Z. So will
Hmm.
Y also be liable? Like, will the intention be common or no?
No, but depends. Did he kill him right then when they decided it?
No, no, no.
Afterwards?
Yes.
Afterwards, if he's killed, let's say, then of course, I mean, the prosecution may say, yes, this person also had the intention and these people shared this intention. But it is for the defense to then prove that, because he was in a drunk state and this was not actually meant to be a serious conversation. So, it's a debatable question, of course. The prosecution may, of course, say that they had a common intention, because even if you jokingly, talk about something which is a crime, it's a crime, and you can still be guilty of criminal conspiracy.
Okay. So suppose now if they are not drunk and they just discuss about their
Right.
enmity and their desire to kill Z. X
Right.
without discussing with Y goes ahead and kills Z. So still will it be?
Of course, in that case, so there is clear intention because the parties had intention. Whether both of them kill him, one of them individually kills him, doesn't matter. As long as there is an intention which is shared with each other and there is an offense committed in furtherance of that intention, they both will be tried and convicted for it.
Here, there are two persons, A and B, and their intention was to go and kill C. Okay.
Okay.
In that process, they went to the place of C, and B and C started assaulting him. In meantime, A got an idea that I should not kill him. We should stop him. We should only assault him.
Okay.
But unfortunately, before the A implements his thought on B to stop killing him, only assault him, but C died because of the force used by B.
Hmm.
He is also liable for the prosecution of criminal prosecution because he is trying to save the person again.
No, no, doesn't matter because you may have a change of heart any moment. You may
Mm-hmm.
shoot someone and then regret it immediately, then say, ki, oh no, I should not have shot him and I
Mm-hmm.
should now try to save him. But that does not mean the criminal part of it goes away. You have had the intention to kill him. You have done an act in furtherance of that intention. Now,
Mm-hmm.
merely because you had change of heart, then that does not mean that, you can run away from it. Of course, in facts of such situation, if you can show to the court, because
Ah,
the court will eventually look at the fact
okay.
whether after had you guys had a common intention to kill him, you go and assault him, then you realize that maybe I should not have done this. You
Mm-hmm.
had a second thought and you think, yeah, I should try to save him, and you
Mm-hmm.
take him to the hospital. The accused person takes him to the hospital. Then of
Mm-hmm.
course he can show that look at my bona fide. I did not want to kill him. If I wanted to kill him, why would I have taken him to a hospital?
Okay.
My intention was only to assault him. And
Mm-hmm.
when I realized that the other accused person has, beaten him red, blue, which was more than what my intention was, I immediately took to the deceased to the hospital to
Mm-hmm.
give him a treatment. So of course, in that case, in those facts, that accused person can take that defense.
Okay. Okay. Thank you. Thank you.
In a case of domestic violence, a
Right.
woman is harassed by her in-laws and her
Okay.
husband. Okay,
Okay.
she is just abated to commit suicide.
So she
Okay,
commits suicide.
no, 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 no. I mean, like the way she's harassed,
Okay.
yeah, it will amount to abatement to suicide.
Okay.
But one day the husband murders her.
Okay. So can the family members of husband be tried?
Yeah.
No, because murder is a very distinct offense. Had she committed
Okay.
suicide, then of course the family members of for abatement of suicide they could be tried. But murder is a very
Okay.
distinct offense from that, so they cannot be tried.
And will they be tried for harassment then?
No, unless you can show that because that was her intent. Because eventually she didn't die because of suicide, which was due to harassment. So unless you can show that this was harassment was going on and she had intention to commit suicide, and before she could commit suicide, she was killed by her husband. So their family members should also be roped in and tried. I think so. This is not a fit case where the court will try the family members because when someone is tried for abetment of suicide,
Yeah.
the date when the suicide has happened and the harassment, their gap should be very less to rule
Hmm.
out that it was not because of any other reason but due to the harassment that she has committed suicide.
Yes.
Thank you so much for having me.